Hi, everybody. I hope everyone had a great holiday season and everyone's getting back in the swing of things for 2023. I know there's still a few people who are logging on and joining us, but I wanted to go ahead and welcome you to our webinar, What Carriers Need to Know, Maintaining Compliance in 2023. I'm Molly, and I'm here with 10th Street's General Counsel Shannon Wheeler. And for everyone who has made the time in their busy day to be with us as well, welcome and thanks for hanging out with us for the next hour or so. I'm really excited about this webinar, but first I wanted to take the time to invite everyone to our 5th annual user conference. Our 5th user conference is going to be taking place April 12th through 14th, and we'll be back at the Bellagio Hotel in Las Vegas. We're going to gather our vendors, our 10th Street experts, and our clients to connect and share knowledge with some Vegas fun squeezed in along the way. If you enjoyed today's webinar, I think you'll definitely enjoy your experience at the user conference. We'll share the latest compliance news and industry data. And as a little added bonus, all attendees receive free access to our latest innovations for 90 days before everyone else, and then receive a discount on those products once they're available. So Shannon, do you have anything you wanted to add about the user conference?
Sure, yeah. Hi, everyone. Thanks for joining today. I highly recommend the user conference. I'm there. I've been the last 2 user conferences, spoken at them, met so many people in person, talked through big issues. It's a phenomenal experience. It's an incredible place. Our focus in putting this together is what can we do to create value for you? What would be valuable to show? What would be valuable? And then of course, we roll out a bunch of new products, which are really fun and interesting, and we're already working hard on those. I can't wait to roll them out and tell you all about them, but it's just a great, phenomenal experience, and we design it so that you get a whole lot out of it. So I hope you guys will come, and if you do, come introduce yourself to me. That would be great to meet.
Yes, and if you do want to register, you can do that at www.10thstreet.com/user-conference-registration, or you can just go to our website and find the events page, and there's a little box you can click talking about the user conference, and it'll take you straight to the registration page. So now we can get back to what everyone's here for. We're going to go over all things compliance today with a focus on key changes in the FMCSA regulations, clearinghouse changes, some of the latest updates to the ban the box and wage transparency. And we're also going to discuss how you can perform an FCRA checkup, what's happening with nuclear verdicts, the California Privacy Rights Act, and a few more things. We're going to wrap up with a question and answer session, so feel free to submit your questions at any time throughout the presentation. You can do that under the questions section in the GoToWebinar panel, and we'll try and answer as many as we can at the end. And one last thing before we get started, this webinar will be recorded and emailed to you within the next 24 hours, so don't worry if you get interrupted or have to jump off. You'll get the recording 24 hours after it ends. And with all of that, I'm going to go ahead and pass the mic over to Shannon and let her get started.
Awesome. Thank you so much, Molly. I really appreciate it. Thank you all for joining us. As always, I'm going to give my typical legal disclaimer. This webinar and the information presented does not constitute legal advice. Of course, we always recommend that you consult with your own qualified legal counsel. And if you need any recommendations for that, please feel free to reach out. We can give you recommendations for your own legal counsel, but this does not constitute legal advice. Okay, so kind of diving in, I just want to give, what I'm doing today is just a big, broad overview. I'm not going to dig in too detailed on any of the laws that we're discussing or any of the changes that we're discussing. I just wanted to give you a big broad overview of, hey, this is what to look out for in 2023. These are the things to watch, and these are the things that are going to be coming and that we predict for 2023. It's going to be an interesting year. I can't believe we're even saying the words 2023. It's just been a time work over the last 3 years, but I'm excited to start the year off, and we'll just cover these issues at a big, broad overview. So the first thing, jumping in, is the changes to the DOT employment verifications. Of course, this went into effect January 6th. So just last week, the Clearinghouse became 3 years old. And so what that changed was the regulations said that the Clearinghouse full queries, the pre-employment full query, satisfies the drug and alcohol portion of the employment verifications. So I gave a webinar on this, oh Molly, what was that, November? It wasn't that long ago. And we had a ton of people join. We dug in really deep on what this change is. We had several people on, and it was great. But this is a big change. If you haven't heard about it yet, employment verifications that have been around forever, we're talking about 49 CFR 391.23, where you have to verify employment of the prior employers of the driver that you're hiring. The drug and alcohol section of that is no longer required. So you don't have to request that information, and you no longer have to provide that information. There's some limited exceptions I'm going to talk about here in just a minute. But as long as you run, well, you're required to run, of course, the Clearinghouse full query, but that now will satisfy the drug and alcohol section. You have to still verify the prior employment and accident information. So this has been a little bit of confusion on this, and we've had several people reaching out to us asking, hey, you know, we can just stop verifications now, or you can stop sending me, faxing me these forms now, requesting verifications. No, you still have to verify the employment and the accident information. It only pertains to the drug and alcohol information. So, okay, digging in on the next slide to the limited circumstances where you do still have to get the drug and alcohol information. It's basically when a driver was subject to a drug and alcohol program regulated by another agency, because the only thing that's reported to the Clearinghouse is that which relates to the FMCSA. So if they fell under the Federal Transit Association or the FAA, you still have to get drug and alcohol information on those prior employment verifications. But those are pretty limited circumstances, but it's just an FYI. If you have any drivers related to that, then the Clearinghouse will not satisfy the drug and alcohol section of that. And then also when an employee was subject to follow-up testing but has not successfully completed, basically completed all the way through the SAP program and all the way through follow-up testing, you must still request that follow-up testing plan from the prior employer. So those are the only limited circumstances where you are now required to get drug and alcohol information on those prior employment verifications. So let's talk about what your options are with this change. And essentially it's you can no longer request drug and alcohol information, and you can no longer, if you choose, provide drug and alcohol information on these verifications if that's what you choose to do. But you can also still continue to request and provide drug and alcohol information if you want. It is not prohibited by the regulations or the FMCSA to request or provide drug and alcohol information. It's just no longer regulatorily required, but your options are open. You can continue to do it. If you do continue to do it, you still need a signed release from the driver to obtain that drug and alcohol information. Now, to be clear, you still need the release to get the employment and the accident information as well. But if you're going to request drug and alcohol information, you'll still need your release to say that drug and alcohol information. Now, we've gotten a lot of questions. Are you going to change your drug and alcohol release? Are you going to, make any changes there? And the answer is no. There's nothing wrong with the current drug and alcohol release. There's nothing that outlaws or restricts you from continuing to use that. Of course, if you want to update your release to coincide with what your practices are, you're welcome to do that. I suggest you, get some legal advice on that and have an attorney review it. But as of right now, there's no reason to change the 10th Street sample, and it still functions and works. And especially in the case of, if there is a driver that one of the limited exceptions applies to or something, you have that release on file and you can go request that from prior employers. Otherwise, that release also authorizes accident information and, of course, the prior employment information, so you can get it all with that release. And kind of polling and talking with carriers, I think a lot of carriers were just unsure what they were going to do, but a lot have also indicated that they're going to continue to get drug and alcohol information on employment verifications just for additional diligence. So it'll be interesting to see over the next year what happens with that, but it is up to each carrier on what they decide to do. You just keep in mind it's not risk-free, since it's to either request or provide. Since it's no longer mandatory to meet your regulatory obligations, there's some other potential risks that go along with that. I'll let you discuss those in connection with your own legal counsel, but I did just want to point out, since it's not mandatory any longer, there could be some risks associated with it. So a lot of you may be wondering or curious, if you didn't join us in November, hey, what does this mean for exchange? Because obviously 10th Street's exchange network is where employment verifications are. And we have over 40% of the market where those employment verifications go across. So there's a lot of use there. And we're going to continue to support the requesting and providing of drug and alcohol information if carriers choose to continue requesting and providing it. So if you're going to keep operating your business as you do today and requesting and providing drug and alcohol information, the 10th Street Exchange Network will work exactly as it does today. So we want to support you in whatever you believe is best for your company and the options that you believe. And so we're going to continue to support that. But we did create some changes. And Molly, if you want to go to the next screen, I've got some screenshots here of the changes that went live. I believe on Monday. Our dev team has been working really hard behind the scenes. They're really the heroes who create all this stuff. They changed some, or created, I should say, a new master exchange control setting. And so what it is if you're a primary, you decide, I want to make a change where my company is no longer going to request drug and alcohol information, or across the board, we're no longer going to provide drug and alcohol information. You can go into your control settings, and there's right here this exchange control center, and you can choose. And we make it real clear, if you're going to no longer provide drug and alcohol information, then you click the deny drug and alcohol requesting, or sorry, for requesting, then you deny drug and alcohol requesting. If you want to allow it, you can click allow, and you can turn these on and off as you decide. The same with providing, allow or deny. And so what this allows you to do is go in, and if you're going to deny the requesting, that means none of your users will be able to request drug and alcohol information on the exchange network, and it will show up like this screen down here on the left side, where the drug and alcohol section is grayed out, and this is for a request. And you can see a little pop-up there that says the ability to request drug and alcohol information has been disabled by your company. So turning that off, to the master exchange control setting off to deny drug and alcohol requesting, will then not allow your users, and that's what it will look like. Same with the providing. If you deny the ability for your the master level to provide drug and alcohol information, then down here on the right, that is what will be shown when a requester comes to request from you. It'll be grayed out, and it will indicate the provider has indicated they will not provide drug and alcohol information via exchange. So that's how the new functionality will work. It is available right now. If everybody is auto defaulted to exactly as it was prior to the regulatory change, meaning they can request and provide drug and alcohol information. So if you want to change that, you can go into the new master exchange control settings and make that change. I will say, I know it hasn't been live for very long, and this is a very new change. And we're only less than a week away from when the change went into effect. But we have not had very many companies at all make this change. I think there was fewer than 19 companies that had made any change here. So I don't know if that'll change over time, or maybe after this webinar, but in any event, that's the new functionality. Depending on whatever your company chooses to do, we're here to accommodate it. All right, so I'm gonna go real fast here, since I'm going through a whole lot of information in just an hour and just kind of covering it at a high overview. So I want to talk about real quick just some other key changes that are coming out that I think we'll see this year from the FMCSA. The late December, the FMCSA denied the Trucking Alliance's request to be able to report hair testing results to the Clearinghouse. The FMCSA specifically said they do not have the authority to grant that request, but keep a lookout because the Department of Health and Human Services is set to decide whether hair testing is an acceptable screening method for drug use. And depending on what they decide for that, it could then, and I mean, I think the speculation and the thought process is that if the Department of Health and Human Services decides that it's an acceptable screening method for drug use, then that will provide the FMCSA the authority to go in and do some rulemaking and maybe allow for hair testing results to be, officially a way to test drivers in such a way that it may be able to be reported to a clearinghouse. So keep a lookout for that. Right now, they cannot be reported to the clearinghouse, but that may change this year or, coming soon. So stay tuned on that. Speed limiters. There's a renewed focus by the FMCSA on speed limiters. There were some proposed rules that I think they put out in October of 2022. They took some comment. So we're expecting, or they've indicated that they're expecting to supplement their rules coming this June, in June of 2023. And so this would, be some regulation regarding the electronic governing of speed. A lot of you may already use speed limiters on your trucks, but this would be a regulatory enforcement of that speed limiter. So keep a lookout for that. The next thing I think is super interesting, electronic truck IDs. So there was sort of this advance notice of proposed rulemaking that the FMCSA put out in September of 2022, just kind of inquiring into the industry of, hey, what if we required every CMV to have essentially an electronic ID tag that would wirelessly communicate its unique ID to like law enforcement, like federal or state law enforcement for roadside monitoring and things. And they asked a bunch of questions and got some feedback on that. So more to come on that. It'll be really interesting to see what they do. Automatic emergency braking requirements. They've indicated, the FMCSA has indicated that they are going to require and standardize the performance of AEBs. And so we'll see what that looks like. I think that one's going to come sooner rather than later. They have indicated that they're going to issue some rules in January on that. And then of course, broker and freight forwarder financial responsibility. They have put out their proposed rules right now, and they are accepting comments right now. So if you have a stake in this particular item that the FMCSA is regulating, go and comment now on the rule. So it's always good to let your position and your voice be heard. So that's a very, very interesting one. Carrier fitness procedures, what they're proposing to do here, and we'll see, this may not be a 2023 change, it's just something they're talking about, but is that they will use, the idea they've indicated is that they want to use safety and inspection data to better determine a carrier's fitness to operate. So we'll see what they come out on that. And then of course, I have to discuss carbon emissions out of California. Of course, they have said that there can be no trucks older than 2010 on the road. I think that is in effect. But just yesterday, of course, Biden put out his big broad statement that he wants 0 emissions for large trucks by 2050. So those are more things to come, but this is just a big broad overview of things to watch out for, things to be aware of. If there's anything big or major, especially if it affects your services at 10th Street or services that we want to offer at 10th Street, of course, we usually do a webinar or a blog post or notice or something to inform you of that, but just big, broad things for you guys to watch out for. Right. So some clearinghouse changes going into effect. So we talked about this also on our November webinar. It's a great change that the clearinghouse is going to be doing. It's to continue to close the gap of when positive results come in from drivers. And so what the proposal is, and we'll see, it's coming, it's not in effect yet, but it is coming early in 2023. They indicated in my conversations with them that they expect it to be mid-February. But The idea is that they're going to notify the employer, the registered employer, via email if there are any changes in the driver's status. So any new information that comes in, the clearinghouse is going to push out an alert. And then, so, it gets reported to the clearinghouse, then they push out an alert. They've indicated that this will be emailed to all users that are registered with the employer, including third-party administrators, and that it will also appear in the clearinghouse dashboard. So we're looking forward to that change and to see what all that brings, but it is not live yet. And sort of this next slide, I just kind of wanted to take you through an example of what will happen, or what we believe will happen. And so if in January, ABC Truck hires Dan Driver, and they do, of course, a pre-employment full query, and Dan shows no violations, so he's not prohibited, they start employing him, he is driving for them. While he's still employed and driving for them, he applies at XYZ Trucking and gets a positive test that's reported to the clearinghouse. So he's now prohibited in the clearinghouse, but ABC Truck doesn't have any idea, and they won't know until they go to run the mandatory annual limited query, or if they do a limited query, throughout the year. They won't find out that information unless they actually, run that query to the clearinghouse. And so Dan Driver decides he's just going to lay low and keep driving for ABC Trucking. And of course, ABC Trucking complies with their obligations in December. They do their annual query, and they find out that Dan Driver is in a prohibited status, but he's been driving for them since April. So that's the problem that they're trying to solve. What they're saying is that the clearinghouse is trying to solve with this new update. What they're saying is early 2023, in April, when that positive test was reported to the clearinghouse, when his status changed to prohibited, they're going to push out an alert to the employer that who queried Dan Driver in the last 12 months that there is new information in his clearinghouse. So that's how they're proposed it's going to work. So we'll see. All right, gonna switch gears but continue to go fast. I just wanted to touch base briefly on ban-the-box jurisdictions. These are, locations where, and I've listed here only locations where private employers are required to remove criminal questions from their application. If there's a public employer, like they work for the state, those are not listed here, and those are also not included in the 10th Street functionality because we just don't have enough. And so we keep up with what laws and changes relate to private employers and ban the box. And so if you have or hire drivers in any of these locations and you have the ban the box functionality turned on, which is the default, so most of you likely do, if you want to remove that default, and you can go in and ask your account manager to remove it. But if you have the default, then we automatically remove the MVR section of the Intella app, which asks questions that are often construed as criminal questions and particular violations that they may have had. And because these locations, and they've evolved over time, as you can see, and we continue to add these over time. So, some of the new ones we added last year, I think were DeSoto, Texas, Westchester County, New York. As we get and receive notifications on these, we go in and our dev team updates the locations. And so what it does, it is all based on the location of the driver. So that's the list of our current ban the box locations in 10th Street that remove the criminal questions, or the MVR section, I should say. Okay, we've had a renewed sort of focus or interest, a lot of questions on individualized assessment. So I wanted to talk about it here today. So if you're asking yourself, what is individualized assessment? It means that companies cannot exclude all job seekers with criminal records. So you can't have a policy or a practice that says we're never going to hire anyone who applies to us with any kind of criminal record. That is the federal law. The EEOC says you cannot do that. Instead, they say you have to assess each criminal record for job relatedness and business necessity. So does the crime that they committed or were convicted of relate to the job for which they're applying, and the necessity of the business such that you cannot hire them. And then you have to, and this is the piece that I think there's been renewed focus on, you have to provide the applicant with the opportunity to explain or resolve their criminal history uncovered in a background check. So I'll cover here in just a minute how you can do that. Again, this is required by federal law under the EEOC guidance. There is actual EEOC guidance out there on individualized assessment. It's a very, very long guidance, but it's a good read. If you're not into reading EEOC guidance, then you might just contact your attorney or maybe your HR professional who knows a little bit more about it. But the renewed focus has really been, many states have started requiring individualized assessment. I think there may have even been Atlanta, or there was another city or state that recently pushed out an individualized assessment law requiring it, but that state was just in line with what is already required by federal law. So if you comply with the federal law, then you comply with most of the states that have these laws, except for, and these are the exceptions, the Los Angeles, California, and New York City, New York require that you fill out a specialized form that is required by these states, or suggested. I think New York's is suggested and LA's, New York's is required, but LA's is a sample form, but really they want you to use their form. And so what those are is they'd say, you have to go through and answer these questions about the individualized assessment in with regard to the criminal record of a particular applicant. With all other states, you should document it. You should document the assessment that you did, that the criminal record, if you're excluding the individual in particular from the job, document how it was, the crime related to the business necessity or the job. And then when you do the adverse action letters, you basically just include a statement or a identification of the criminal record that you uncovered in the background check, and that provides the applicant with the opportunity to explain. You've given them, of course, if you follow a two-step adverse action process, which I'm going to talk about later on in the presentation, then that meets the providing the applicant with the ability to explain or resolve it. And so what's really great about our functionality is our adverse action letters. If you've ever sent out an adverse action letter, that when you go through the process, it has a little pop-up box that asks you to fill in any criminal information that is excluding the individual from the job. And you can just type in what that criminal information is, and it will add it to the adverse action letter. There are actually several locations where this is required, and we will tell you that if you bypass it without typing anything in there, or maybe it just tells you this individual is in a location that requires you provide this. And so if it's criminal related, you fill that in. If it's not criminal related, you don't need to fill it in. For Los Angeles and New York, you actually need to attach their special form to the adverse action letter, or that's the recommended advice. And so those adverse action letters go into a ready to mail status, and so that you can print those out, attach the individualized assessment form, and then mail them out. So that is individualized assessment. That is how it works, and that's how it works along with 10 Street's functionality. Okay, moving on to wage transparency. So, there's always a focus on this, and this is a number of locations. These are the states and then Puerto Rico, where private employers cannot inquire into the previous pay of the applicant. And so we created some functionality that in these locations, if the applicant is from one of these states or Puerto Rico, they do not see, I think there's one question on the application maybe that says, what was your previous pay, or what is your current pay, or something along those lines. And we remove that question in these locations. So that's set up for you. You need to make sure, of course, you don't have any custom questions around that. And then each state has sort of a requirement or may have further requirements around wage transparency. So just be aware of that. In particular, if you go to the next slide, the sort of new frontier of wage transparency is that cities and states are requiring actual disclosure of the salary or the salary range in the job ad or in the job posting. So just be aware that in job ads in these locations, you have to have the salary disclosure. So you either need to list the salary or the salary range of the job. So I know that's hard to keep up with and hard to do. You might just always include the salary range, as that's something that you can use to your benefit. But in particular, in these locations, make sure that you're doing that. All right, I am going to switch to now to talk about FCRA, the Fair Credit Reporting Act. The Fair Credit Reporting Act is, as you can see by my chart here, has continued to increase. In 2022, it was one of the only sort of consumer litigations that actually did increase. A lot of the other consumer litigations decreased. But not the FCRA. The reason why 2022 is still estimated is because we don't have December numbers yet. But as of November, I believe it was getting close to 6,000 lawsuits, and they were thinking that December would push it over 6,000 lawsuits. So this is definitely an estimated number still, but we know already that the lawsuits, the FCRA lawsuits for 2022 have definitely exceeded 2021 already. And so really need to be aware of these. The other thing to be aware of is that not only are plaintiffs' lawyers continuing to file these, mostly these are class action lawsuits, and there's so many that have been filed that the plaintiffs' lawyers are no longer just going after the big targets. They're really going after anybody and everybody that that they can still get a dime out of, because these have been, all of these early class action lawsuits, especially 2015 to 2018, were really the big guys and a lot of low-hanging fruit, really attacking disclosures and authorizations. And from here, they're just filing, and it's a numbers game for them. So if you're a smaller mid-sized carrier, you are not exempt from these concerns. So what are we talking about with FCRA lawsuits? Of course, we're talking about your disclosure and authorization to pull a consumer report, and then the requirement to do an adverse action letter. In particular, of course, as you all know, it touches trucking because you are federally required to pull certain background checks, right? So you're required to pull an MVR. Oftentimes the MVR is a consumer report. And of course, all the other reports that you pull, background checks, things like that, are consumer reports, which fall under the FCRA. So we are always looking at compliance. We are always making changes, and we did that at the end of last year. Again, big props to our development team who worked with me on this functionality, and I'm pretty excited about it. And so we made some changes in how state notifications are shown. So as most of you are already aware, we can dynamically present the state notification based on an applicant's residence and a job location. So what I'm talking about here is before, so they fill out the application, the Intella app, and sign it. And then they go into the next pages, which is it's the signature only section, and they're going to sign all their releases. And we show first the FCRA summary of rights, and then we will show any relevant state notices before the applicant then goes in to sign disclosures and authorizations. And so this is the piece of our functionality that deals with those state notifications. We made some changes to. So the previous functionality was that we would present the state notice, the relevant state notice. And by the way, there's 7, 8 states. There's a handful of states that have a required state notice. It's not every single state, but of course it's California, it's San Francisco, it's New York, Philadelphia, Massachusetts. Those kinds of states have a specific notice that must be shown to the applicant. And so we said if the previously we said if the applicant's address is in one of those locations, or if the address of the carrier that's listed on the application is in one of those locations, then we would show that state notice. Or you could come in, a carrier could come in and ask us to turn on a particular state notice to show for everyone who always applies, no matter where they're from. And that still all exists today, that it works exactly like that today. But what we did was we did some added functionality where we can now show the state notice based around job location. So if you use job requisitions, which this is relatively few of you use job requisitions, not very many carriers have job requisitions. But if you do, then we can, and we will, the default is that we will show that state notice when the individual has selected the job requisition for that particular state. So if they have selected that they are applying for a job through the job requisition to California, they will see the California notice, which is actually called the California disclosure, when they go to apply. And so that would in particular show if the applicant was listed, let's say they lived in Nevada, but they were applying for a job in California, and let's say the company's headquarters or their address wasn't in California, then that individual would not have seen the California state notice. Well, now with this new functionality, they will, if they use job requisitions and they apply for a job there, they will see that California notice or any other state that's applicable. We also did it with active jobs, because what we found when we went to implement this is that most of our clients use active jobs. A very large majority of our clients use active jobs. And so we did some great thought processes around this. And we said, okay, so if they're applying from a job, like from a job ad or a link that is an active job that is in a state that has a state notice, then even if the applicant isn't from there or the carrier's address is not from there, we will show that particular state notice, just like I described how it will work on job requisitions. And then we know that not all active jobs are, just one state. And so what we didn't want to create was, well, if there's an active job that's, listed for all 49 states, we don't want to show all state notices, because that doesn't really solve the problem, right? The problem is that you really want to narrowly tailor and show that only the really applicable state notice. So we said this will only work if there are 3 states or less in the active job. So if it's an active job for 1 state, great, it'll work. If it's an active job for 3 states, great, it'll work. It'll show that that particular state notice. But if you have an active job for more than 3 states, it will not show the state notice dynamically. It's still going to go off the previous functionality, which is the address of the applicant or the address of the carrier. And of course, you can always decide to turn on and show state notices. You can also decide to turn them all off. So we're here to help you with your compliance changes. This is a lot of work on our dev team, and really great functionality that we have recently added to help keep you as compliant as possible in our system and protect you from FCRA lawsuits. And really the other states, yes, it works like it is, but really this is around California, because that's where the liability is strongly exists, is a lot of these FCRA lawsuits are being brought in California, and specific to and around the California disclosure. So in a very quick time, that was the new compliance changes on state notifications. Okay, so jumping next to how can you do an FCRA checkup. So often in talking with carriers about the FCRA, I hear that it's, oh, we set that a couple of years ago, or we set that 5 years ago, and we haven't looked at it since. I mean, it's not something that they go back and review often. Well, now's a good time. Try to find some time. You all might be really, really swamped and busy right now, but try to find some time in the next month or two, just go in, make sure that your processes are what you want them to be, make sure your the release language is what you want them to be. If you haven't updated it in 5 years, you definitely need to go and do a review. If you updated your, let's say, your disclosure and authorization a couple years ago, you're probably still good, but it's always good to do a checkup. I actually have 2 steps listed here. And step 1, surprisingly, I actually put the 2-letter adverse action process first, mostly because we've put a lot of information. I've been talking about releases and disclosures and authorizations for a long time, what to have, what to not. And a lot of you have done a great job of reviewing those and updating those. But what I'm seeing more and more of is problems with the adverse action process. Some people don't have an adverse action letter. Some people are asking me, what is adverse action? So I really want you to go in and look at your adverse action process, or if you don't have an adverse action process, consider having one. And we've got some great previous webinars that dive real deep into the adverse action process and what it is and what the recommendations are around that. Of course, work with your legal counsel, but make sure you have a 2-letter adverse action process. I've talked with several people lately who still have just a 1-letter process, which technically speaking is allowed under the FCRA, the actual text of the federal FCRA law for trucking. However, states have now, lots of states, particularly California, have implemented their own FCRA state law, and no states have authorized a 1-letter process like the federal FCRA has. So there's a decent chance that if you're using a 1-letter process that that the states that you're operating in, you may not be compliant in. So that's one key. The other key is that if you use your adverse action letters to also send out PSP and Clearinghouse, so PSP and Clearinghouse aren't technically consumer reports, but they do have a contractual requirement that you notify the individual if you're taking adverse action through a 2-letter process. And so the processes that the PSP and the Clearinghouse require, if you do a 2-letter adverse action process, you're going to comply with those requirements. So that's why I recommend it. Also, even if you use a 2-letter process, go through and review the adverse action tool within 10th Street. Make sure that those letters are going out like you think that they should be, like you want them to do. We tell you in the dashboard, in that tool, if it was successful. We tell you if it was delivered. We tell you if it failed. We tell you if it's in a ready to mail status, because sometimes there's some circumstances which it's not appropriate to email the adverse action letter, and so you actually will want to print that out and mail it out. Those circumstances are kind of like what I described earlier with the individualized assessment form. Those go into a ready to mail status. Also, if there is like a Pennsylvania MVR, there's a Pennsylvania law that says that Pennsylvania MVR should not be in any third-party electronic system. Sometimes they are, sometimes they aren't, but we assume that they are not, and so Pennsylvania adverse action letters all go into a ready-to-mail status. There's some other things there, like if you don't have any consumer reports, then there might be a notification there that says, hey, this hasn't gone out, or if there's an email problem or something. So make sure you look at that tool each time you send it and make sure it gets sent. Also review, this is a great time, review your internal processes, make sure that you're disclosing criminal information on the adverse action letters, make sure you're doing the individualized assessment, or you have at least a written policy about doing it. And then make sure you know what to do if a candidate does come back to you and dispute something on a consumer report. Like if they say, hey, I'm John Smith, but I'm not that John Smith, you've got it wrong. What do you do? And what is lawful and required there? So go review all those internal processes and give yourself a little bit of a checkup there on the adverse action process. And then step 2, of course, with the releases, go review your, and update your release language if it's needed. Make sure that you have a standalone disclosure with no extraneous information. That's key. That's the big requirement here. Make sure that it still fits with your unique hiring processes and says the things that you want it to say. Of course, 10th Street has a sample that we put out there and that a lot of our clients adopt, but we don't know your individual unique hiring practices. So make sure that it does fit with that. And then of course there's the 1681M notice that has consumer reporting agencies on it. Make sure that all of those are your current CRAs. For that matter, make sure that they're current in the adverse action letters too, because those list all your CRAs there. So go do an FCRA checkup. Those lawsuits are out there, and we will see more of them in 2023. That's my prediction. Switching gears, and I'm going to just move real fast here because I'm running out of time. I'm trying to cover so much. Nuclear verdicts, we have heard about this for years. It's been the top of our mind. It's been the focus. How could it not be with these gigantic nuclear verdicts? It's easy to get a little bit immune to it. Keep it top of mind. It's going to continue. I pointed out some of these very litigation hotspots. Florida, Georgia, Louisiana, Illinois, and Texas. Texas, not so much anymore. They have implemented HB 19, which is great for, sort of trying to curb the strength of some of the decisions or the verdicts that were coming out of Texas. But, so we'll see. It's yet to be seen what HB 19 will have an effect on. But I think it's going to do good things there. It's funny. I call them litigation hotspots here. They are commonly referred to amongst defense attorneys as judicial hellholes. So I decided not to put that in a slide. But if you have ever experienced a lawsuit, especially a catastrophic accident lawsuit that was at issue in one of these locations, you know what I'm talking about. And then the other thing to just be aware of that's happening in the industry is that litigation funding, where these third parties come in and actually fund the litigation, are forcing a higher settlement, and they're saying you can't, they essentially make the economics such that a plaintiff can't accept anything that is lower than the amounts that have been funded. And then of course they want to get money out of it, so they want it to go higher. And so that's also something that's forcing these cases to go to trial, or we're actually hearing the term nuclear settlements now, because companies are afraid to take a accident liability case to trial in Florida, understandably so. So just be aware that is still happening. The next slide is really continuing on with the bad news, going through some of what the nuclear verdicts that we've seen. Of course, in 2021, we saw the really headline shocking $1 billion verdict in Florida. That one was against two large trucking companies. And then the $730 million verdict in Texas against a large carrier as well. But what we're also seeing, and what I wanted to point out, is that nobody is immune to these, that really they're not only against large carriers, but they're against mid-sized to small carriers as well. In Florida, a few years ago, the $411 million went against a single owner operator. And of course, we know that the plaintiffs don't recover these amounts, but what they do have the effect of is putting these companies completely out of business. There was a $27 million nuclear verdict in an accident liability case out of California against a mid-sized carrier. That carrier in particular had a little more than 800 trucks. There's a lot of these. When I was kind of digging in and doing some research, it's a lot of these, $20 to $40 million that against mid-sized carriers. That's just killing the industry right now. So just be aware that they are still happening. One that I thought was really notable that came out just recently in November of 2022 was a $7 million verdict in Michigan. And this was a small carrier, 5 trucks. It wasn't even a wrongful death case. The driver of the other vehicle was injured and injured badly, but $7.7 million. So we're just seeing, so that's why it's on here, even though it's less than a $10 million verdict. That's why it's on here, because it's just the circumstances of it. So anyways, and then of course there's what we're seeing a lot of now is these large nuclear settlements, which of course are confidential and unreported. And so you're not seeing a ton of these big verdicts. Like in 2022, we didn't see a whole lot. And I think it's because cases are settling and they're just not going to trial, which, it is a bit unfortunate. So the National Highway Traffic Safety Administration has said that, traffic deaths have reached a 16-year high, which is not great. There were 37,000 fatalities involving a large truck in 2021. So I put a slide on this just to say this accident liability risk of a nuclear verdict is just not going away anytime soon. So keep a focus on it. And so let's talk about that and what that means. There's been a lot of industry changes, right? So there are the ATA, the TCA. Molly, if you want to go ahead and switch to the next slide. They've been fighting. They've been fighting for state tort reform efforts. Of course, that's what happened in Texas, and we'll see. I think that's great. They've also been doing some PR things for the industry, you know, really harping on how truck drivers, especially, were the heroes during COVID, and really pointing to how we really need trucks on the road. And then there's a lot of theories and litigation methods to counter the reptile theory. There's this idea of the mongoose method, and mongoose is an animal that I guess eats reptiles. And there's just some litigation methods that lawyers are using to counter the reptile theory at trial. But there's also been, within the last 10 years, changes within the operations and culture of carriers. You know, now it's very clear, mostly across the industry, with the majority of companies, that safety is a top priority, which is a good thing, right? A lot of you have probably been doing it for a very, very long time, but it has been a noticeable shift in the industry. Of course, there's been adoption of lots of safety equipment and lots of safety practices and changes in hiring practices. So next slide, please. But the point of all this is just to say, stay diligent. So this year in 2023, refine and tweak your safety practices. Continue to add more, continue to think about it, continue to change to be safer, to be able to document what you're doing that's safer. Stay up to date on the FMCSA safety recommendations. The plaintiff's lawyers point to the FMCSA. Now, they say that they're the minimum standard and you should do above and beyond that. Of course, there's arguments against that this is the standard, that's not the minimum, but that it is the standard for all to follow. But in any event, the point is, stay in line with what the FMCSA is recommending on safety and requires. Otherwise, you will just get killed at trial and in an accident liability case. Continue to add safety equipment to vehicles. You might already have cameras. Continue to add those cameras. Continue to add, the braking technology and all of the things that that exist out there. Technology has really been great, adding safety equipment here to trucks. And then continue with your best practices in hiring and retaining drivers. So really, in a nuclear verdict case, it comes down to the claims are usually around equipment or the drivers. That's usually where they attack, the plaintiff's lawyers attack and go try to get these verdicts to be really high. So hone in on your hiring practices, see where you can make some adjustments about your qualifications on drivers. Focus on training. If you're training your drivers well, then you can point back to that. Focus on retention of those good drivers, right? And if you've got a good driver, try to keep them. Drivers are on average in the market 2 times a year. So try to keep them for longer than a year. Try to keep them, 18 months. That will have an effect on the safety practices of your company. Obviously, you want to keep them around for, forever, but that might be, an unrealistic goal. So 18 months is, better than a year, which is better than 6 months. Continue monitoring your drivers. Do, of course, you have to do the annual MVR, do continuous monitoring MVRs. Right now, there's no new information being pushed out by the Clearinghouse. Of course, watch for that to come, but do Clearinghouse checks. Make sure you're doing that. Make sure you're reviewing that. And then, of course, continued supervision and management. That means document. Document when you're talking to your drivers. Document when you're meeting with your drivers. I'm going to go real quick because we are running out of time. I'm sorry, guys. But the next slide, driver and employee training. Now's a really good time to push out new training. Do bulk refresher courses for drivers. Do it for your employees and your safety managers. We've got some recommendations here. These were from Marilyn. So she always has great recommendations. You can also implement CSA infraction action. If you're not familiar with that, it's a really great product. We have your CSA data. We can connect to that, and then we can automatically send out training based on infractions and things that come into the CSA to your drivers. And the same other driver management tools, we can do company-specific point-based training that you send out. I'm going to run quickly through the next slide. Have a great safety management solution. So being a safety manager is a really, really hard job. You have 1,000 different things you're looking at, different problems that you're solving each day, probably multiple systems that you're signing into. So in particular at 10th Street, we have an interconnected solution that brings together all the places that you sign in and look at. So if your telematics data, your CSA scores, you also have your DQF file, your equipment tracking, and your training. All of those things we can bring together into one login, see it all in one dashboard. It helps, the key here is that it helps you monitor and supervise your drivers. It helps you communicate with them when you can more easily identify a problem. And then, of course, we also have the integration with driver's legal plan, which will allow you to, assist your drivers in disputing, a ticket or something, and can help reduce your CSA scores and your driver risk profile. So that's our safety management solution, and it's really highly recommended. It really makes a difference in your risk if you can bring it all together. So consider doing that if you don't already have it. Okay, real quick, California Privacy Rights Act, totally switching gears away from nuclear verdicts. This was enacted in California effective January 1 of 2023, but the California legislature has said we're not going to pursue enforcement until after July 1st of 2023. So even though it's in effect, it's really not in effect until July 1 of 2023, but there's some, it applies to large companies that have California individuals' data. It gives employees, it does relate to employees. It's not just California individuals that are non-employees. It is employees, and it gives them some rights, but they importantly have no private right of action. These rights of actions will be brought by the state, but it's a right to know, a right to correct, a right to delete, and a right to a copy. You should also, if it applies to you, you should talk with your privacy lawyer. If you have a privacy policy that it applies to employees and has a notice of collection or notice at collection, send that to us and work with your account manager on that. We can link that to your Intel app. And just be aware that there is going to be more and more and more privacy rules that come out, maybe not in 2023, but more to come as this, is one of the new emerging laws that will move across the country. Okay, and then the last thing I want to touch on is just some other notable news that has come out recently. There's a California's AB5, of course, we lost, or the Supreme Court declined to review the case with the California Trucking Association, but the California Trucking Association is still fighting for an injunction on AB5. It is in effect, it is active, and it applies to the ABC test, which has the effect of not allowing carriers to use independent contractors in California. There is a new hearing in May of 2023 on that. Real recent news, the FTC has come out with a proposed rule. You can go comment on it now if you want to voice your opinion, where to ban non-compete agreements. So this would be employers, it says employers will not be able to ask paid or unpaid employees, independent contractors, volunteers, apprentices, anything to sign any form of a non-compete. It will apply retroactively, meaning employers will have to rescind all of their previous agreements that are in effect within 45 days of when this rule goes into effect. Of course, the FTC has certain concerns, employers have certain concerns. They say, IP is at risk, they, other things. It will vastly change, sort of the playing field if this goes into effect. And then, of course, the last thing I'm going to talk about, I-9s. The DHS and ICE extended the policy of allowing remote virtual verification of documents for the I-9. So that is in effect until July 31st of 2023. There is some speculation that we could see a permanent change here. So keep your eye on that. That could change. Okay, sorry to have run through all of that so quickly, and we're already at the end of the hour, but let's see if we can at least fit in 1 or 2 questions. But I really appreciate you guys staying with me and hanging through for all that.
Awesome, thanks. We don't have too many questions, but someone did want to know if there was a benefit to running Clearinghouse queries biannually versus annually.
So the benefit right now is because the information isn't being pushed out from the clearinghouse yet, you don't know if there's anything in there. So Yes, there is a benefit that would be going above and beyond your regulatory obligations, and you would potentially see if any drivers have a violation that you wouldn't have caught for another, say, 6 months, if you only run them annually. So there is a good benefit to that. But keep in mind, this new change to the clearinghouse might sort of obviate the need for that, as they're going to be pushing out the information. So we'll see how that works when it goes into effect. But it's a good practice. It's a good practice in theory. And then maybe with the new changes in the clearinghouse, you might not need it.
Perfect. And then one last question. I think you did cover this, but just one more time. Will 10th Street change the verification forms by removing the drug and alcohol questions?
No, that will still exist if for the carriers that want to continue requesting and want to continue providing, that will still be on there. Also, because there could be the limited circumstances where it's still needed, they will still be on there. It's just the information no longer has to be filled out. If you choose not to provide it, you don't have to provide it. If you don't want to request it, of course, I showed you if you go through the network, what will happen in the system, and of course, it won't request the drug and alcohol information. So yeah, we will not change the form because of how open-ended the law is on this, but you of course can choose to do that at an individual level.
Perfect. And then one last question. Are people doing BQA as a way to notify the candidate that they don't qualify?
I'm not sure what BQA means. So sorry, I'm not quite sure how to answer that. The best way to respond to a request or to notify the candidate that they are not qualified is to send out the adverse action letters. I highly recommend doing and following the adverse action letter process.
Awesome. Well, I don't want to take up too much of everyone's time. So if we didn't get to your question, I apologize. You can send me an email reply to the recording, and I will try and get that question to Shannon so she can maybe help you out. But like Shannon said, this isn't legal advice, so also your lawyer would be a great person to ask as well. Shannon, is there anything else from you?
Nope, thank you all for joining. I hope you enjoyed just a big, broad overview of what's to come in 2023. I wish you all the best, and I hope to see you at the user conference.
Awesome. Thanks, Shannon. Bye, everyone. Thanks for joining us.